Good evening, everyone. This is your instructor, Klyde Villamore, and I'm going to discuss about the relevant laws and ethical considerations related to the topic on technical writing. But before that, I'm going to ask you a motivation question. What would be the difference between legal and ethical considerations in technical writing? For you, what would be? Yes. Legal and ethical considerations are different simply because we talk about legal considerations, we talk about the relevant laws that are present in order for us to be guided on how to use a certain thing or in writing, and if it's complacent, or it goes to show that it complies with all, compliant, if it's compliant with the um, existing laws that we have here in the Philippines. So here in the Philippines, according to the Article 100 of the Revised Penal Code, any person is criminally liable is also civilly and administratively liable, meaning that if you commit an offense in the law, a criminal offense, for example, plagiarism, you will also be can be filed by civil damages, and also you can be administratively liable within your local ordinances. And also, it's a different story when we are talking about ethical considerations. Ethics, by definition, it's your um, concept in philosophy or love of wisdom, which talks about how us um, humans, as rational beings, we have the rational choice, according to the social sciences concept, the rational choice theory. We are rational beings, so we are able to discern from what is right or wrong, good or bad, desirable and undesirable, in, for example, in the teachings of God, our sources of authority, in the relevant laws that we have, and also it's compliant to one's culture. So without any further ado, let's hop into the discussion proper. So there are four bodies of law relevant to technical communication. So copyright law. These covers the protection of the right of the authors against those who will um, copy their certain logos or their brands. Or for example, in TV series, they have copyrights. For example, in Darna, way back in 2009, it was Jim A's copyright. They all have the rights on what to do, on what with- to add new flavor in the new series. And in the recent um, prequel or retelling sequel of the beloved Filipino heroine, we have um, Darna, and the um, s- the leading lady was De Leon. So I mean Jane De Leon. Sorry, Jane De Leon, who starred as the new Darna. So there were new characters, new villains, because um the plot in Darna 2009 should not be used in the new sequel because of the copyright that GMA acquired during that time. So, for example, in technical writing, a technical writer preparing a user manual for a software product cannot copy installation instructions from a competitor's manual without permission. Instead, they must write original content or obtain a proper license. So this gives the creator exclusive rights to reproduce, distribute, display, or modify their work. So with this, we are able to be um, aware and be mindful about copyright claims. And if you um, go against these rules or laws, then you will be criminally liable because this is a criminal offense punishable under the revised penal code. This is a felonious act. So a felony in law is an act or omission punishable under the revised penal code. So we have here a case way back in 2010, and the ruling was recently on 2021. So Oracle sued Google or Google for using Java API code in the Android operating system without permission. The case revolved around whether APIs are protected by copyright. With that, um, that is the fact, and then the issue. Then the ruling of the court was the United States Supreme Court, or the highest court of the land, or the court of the highest order, ruled in favor of Google in 2021. So you see, the length of the body of the case from 2020 to 2021. So it took 11 years. So a speedy case or in trial proceedings would not be um, possible or plausible if simply because there are other issues that um, tend to be um, more serious than this. So with that, this case favored Google and stating the use was fair use. So with that, um, the case was junk, and then Google won as the because there are two in a case there are two um persons in a case. Here we have a petitioner. The petitioner of the case was the Oracle, and Google is the respondent. So the respondent, Google, won in the said case. And stating that fair use was um, utilized by Google. So with that being said, the best practice are made explicit in this slide. So what I can provide to you is to always create original content. I mean, original content or obtain permission to use third-party material. So always, always create, if you can, a an original content. And if you want to um, obtain um, content, so you must first obtain permission to the third-party materials, and also use public domain or licensed images, and lastly, when citing sources, follow proper attribution. So with this said, these are remedies or steps on becoming more aware or mindful, not to be criminally liable about um, copyright claims. So trademark law. Trademark law is different from that of copyright claim because this pertains to federal protection. So, for example, a technical writer creating marketing materials for a smartphone cannot use the Apple logo without Apple's permission. If they mention iPhone, they should include the trademark symbol TM or R where required. This prevents authorized use of registered trademarks that could mislead consumers. So, the buyers of a certain thing, these are the consumers. So, with that being said, um, this protects the trademark in a certain company or a certain logo from a coffee shop, and to name a few. For example, in Starbucks, you cannot reproduce the same um, logo because it would impair their rights, their their claim of the logo, and also you will be criminally liable and also civilly liable for this if you do not abide with these existing laws that we have here in the Philippines. So it also gives potential consumers or buyers confusion simply because there are two um, companies using the same logo. So it's not um, this is not um, this is not possible to do because it impairs the vested rights that a certain company has. They are protected by this trademark law that we have here in the Philippines. For example, also in Crispy King, so we also have a new um, fast food or a carinderia, which is similar to it. For example, um, Crispy King and Mr. King. So they're different because the use of pronouns or nouns is different or article, and also the logo is different. So the trademark law will not be um, they will not be liable for the trademark copyright claims of the a certain um, company or um, an investor. So best practices that I can provide is use trademarks correctly and include appropriate symbols like TM or R. And also avoid using brand names generically. Use tissue instead of Kleenex in technical documents. If using a company's trademark, include a trademark attribution statement. So a trademark attribution statement is a statement that the company allows you to use or utilize the company brand or logo. And we also have here the contract law. The contract law covers written warranties or their implied warranties. So in a contract is meeting between the minds of a person to the another person. So contract is legally binding if it um does not impair a vested right enshrined in labor code of the Philippines. I mean in the laws that we have here in the Philippines. For example, in labor law or with regard to employment, so all contracts should be um, compliant to the 1987 Constitution because the 1987 Constitution is basically where all laws should abide to. So, for example, in a company hires a freelance technical writer to create an operations manual. The contract states that the writer must complete it within 30 days. If the writer delivers the work late, the company could legally withhold payment due to a breach of contract. So this may include employment agreements, service contracts, or confidentiality agreements, which is very important in labor laws. So Here we have the Presidential Decree number 442 of the Labor Code of the Philippines. So, in a certain contract, a breach of contract is um, demandable, legally demandable against an employer if a employee does not um, really do his work properly, and also um, he can be sued, or a legal or a liquidated damage can be filed against the employer to the employee. But mm-mm-mm, we also have to look into the employees' rights, because in what the President Manuel Quezon stated in labor laws, that the less in life should have more in law. So, meaning that employees should still be protected by the law, simply because they are doing their work, doing their best in order to give their service to the company. And that's why we have here um, labor codes or statutes in the Philippines, which seeks um, to really take care of the rights of the um, employees. So, for example, in contract of a certain cautionary company, a an agent can immediately resign if he has all necessary documents, medical documents, which states that he or she is and physically fit or mentally capable to do his work. If he is burned out or has mental issues with regard to the work related concerns. That's why it's important. That's why the rendering period will not be um, sanctioned or be given to that certain employee. So he cannot, or he or she will not anymore do the rendering period because of his or her health issues or concerns. So you see, laws are really important here in the Philippines, so that um we can abide to them, and we can abstain ourselves being um being not to follow a certain rule of law, because a law is a rule of conduct, just, obligatory, promulgated by legitimate authority for common observance and benefit. So with that, these laws benefits not only the employers but also the employees, especially the employees. So even an employee has breach of contract, we also have here the section 1 of the Article 3 Bill of Rights 1987 Constitution, which states that no person shall be deprived of life, liberty, and property without due process of the law. There is still due process by the law. Okay. So there is an authorized cause and just cause. So an an employer can unjustly terminate the contract of his or her employee if he do things, for example, tardiness or absenteeism, bre- also breach of contract, and also if he gives data or has HIPAA violations, which are numerous in terms of these violations at hand. Also, he displays um, demeanor, which is not acceptable in the workplace, and also if he stole something. So that are just example that is just an example of um just causes. And also in authorized causes, this is where if an example, if a company goes bankrupt, so they can lay off employees, but the employees should be still given a severance pay. They're also entitled to the final pay of the work that they rendered. So yeah, I hope I made explicit to the contract laws that we have here in the Philippines and the benefits or responsibilities of an employer and also an employee within a certain contract. So best practices as an employee, we always should read and understand contracts before signing. So as BSed English majors, I hope this is clear to you that we always must read and understand or comprehend contracts before signing. This is a common sense. We should always use our sentido común, and we should clarify ownership rights of written content in work for hire agreements, meaning that in work for hire agreements, we should always um, clarify the ownership between a certain logo, in brand, or in a contract. We should not stipulate we should not um do things that would hinder us to be successful in our workplace. And if so, we breach the contract that we have, so we will be criminally liable, civilly liable, and administratively liable as provided in Article 100 of the Revised Penal Code. So third, confidentiality and NDA terms when handling sensitive information. So sensitive information is strictly um, should not be um, produced, meaning that it should be confidential strictly for one's eyes only. For example, your contract should be only between to the employer and employee, for example. So liability law. So again, our liability laws pertains to responsibilities or obligations of writers, especially claims they made on their paper. So what I've been saying, any person who's criminally liable is also administratively and civilly liable. Meaning liable, you are committing a greater offense. So these are the consequences of your actions. So criminally liable ka. So for example, a poorly written assembly guide for a medical device omits a crucial safety step, causing a user injury. The company could be sued for failing to provide clear instructions, and the technical communicator might be held responsible if negligence is proven. So negligence is culpable felony. This arises from negligence on the part of the technical communicator, and since there is reckless imprudence, meaning imprudence, you were not wise in doing that simple thing or being prudent. So that is why you are you can be sued for um you can be criminally liable, but also you can be civilly liable. So civil damages can be sued also to you. This is no civil damages is a, a certain penalty that arises from the liability that you have as a writer. For example, so writers must ensure manual safety warnings and instructions are clear and compliant with industry regulations. So these are understandable, right? So I don't have to explain this further. So provided in the um, Toyota's recall lawsuit in 2010, the poorly written accelerator pedal instructions in Toyota cars led to unintended acceleration accidents. The company faced lawsuits and had to issue a massive recall. So here, it's really important to really um, be calm. As a technical communicator. You should really um, be wise or be prudent on how to really use your advanced knowledge in technical writing and use um, instructions that are clear, understandable, and also it's simple and clear to the reader of that um, instruction manual. So, as English majors, you are um, already equipped with the knowledge in syntax or grammar and also in semantics or the study of literal meaning in language. So apply it here, and with that, um, you can be saved from the liability lawsuit, or you can abstain yourself from being criminally liable and be liable to a lawsuit in the near future if you become a writer or a technical writer someday. So best practices I could provide to you is always include clear warnings, disclaimer, and a procedural step-by-step safety instructions in the user manual guide. So follow industry-specific regulatory guidelines. For example, in occupational safety, health, and hazards, or OSHA, FDA, ISO certified rules, and ensured translated documentation conveys the same level of clarity as the original. For example, in a user manual, for example, in a smartphone, we also have here is a user manual. This can be translated in English, and also this should also be translated to the um, source text, meaning to the place where it was bought, for example, in China. So typically, kay bawman mo nga kanang some things or most of the things that we buy are things from China or made in China. So, for example, if the user manual has Chinese um, letters or characters, it should also be translated in the um, language that we all know, or English, because English is the language or the lingua franca that we all know. Lingua franca, it's the bridge, it's the language that bridges us together because it's our common language that we all know. So, with that being said and done, technical communicators must navigate these four bodies of law to create a clear, accurate, and legally compliant documentation. With that, we, as technical communicators, are as English majors, uh, understanding copyright trademarks, contracts, and liability laws helps us prevent lawsuits, protects intellectual property, and ensures user safety. So we go on now to ethical considerations and technical communication. So the dose, I mean, be clear and accurate. We must provide factual, precise, and up-to-date information. We should, again, use simple, clear language suited to your audiences. Third, include step-by-step instructions where necessary. Second, prioritize user safety by clearly state warnings and potential hazards, follow industry guidelines for safety documentation, and third, foreground or highlight emergency procedures where applicable. Third, credit sources and respect copyright. Cite all external references, images, and content used. Follow fair use policies for third-party materials. Obtain permission before using copyrighted text or images. So these are understandable, and this does not require um you- anything to flesh out because these are clear, and it fleshes out the importance on really obtaining permission first before using a copyright text or image. Or be transparent and honest. So honestly, if I know that I may sound like a broken record, but honesty is the best policy. So be transparent and be honest because with this, it discloses product limitations and risk. And with that, we can avoid exaggerating product capabilities and provide realistic troubleshooting steps. And lastly, ensure accessibility and inclusivity. And here, I always make explicit to use plain language when possible, provide alternative formats. For example, audio, braille, or large text for visually impaired users, and avoid biased or discriminatory language. So this is common knowledge to always be neutral, always use neutral language because we have um because discrimination is unacceptable, especially the laws that we have here in the Philippines. The don'ts. Don't mislead or withhold critical information. Don't omit important details to make a product seem better. Also, don't use deceptive wording to mask risk. Don't hide disclaimers in fine print. So, for example, disclaimer: this in a certain product, this does not hold any therapeutic claim. For example, like that. So it does not guarantee that that certain product will work or be effective when you use it. Second, don't plagiarize or violate intellectual property rights. Don't copy text or images from other sources without permission. Don't present someone else's work as your own. Don't reuse proprietary information without authorization. For example, in my thesis, if someone took my thesis without my um knowledge or my permission, so he can be criminally liable to intellectual property rights. Third, don't use bias or discriminatory language. Don't use gendered or feminist or sexist language, racist or exclusionary terms. This is made explicit in my thesis. So don't favor one product, service, or brand unfairly unless comparisons are justified. Third, don't ignore diverse user needs, different literacy levels, or disabilities. Four, don't ignore user feedback. So feedbacking is really important here, not only in a classroom setup where teachers provide feedback to the performance of their students, but also here user feedback is important because this um, just to show that we are open to suggestions, criticisms, and also um, we can um, really see that we cannot dismiss customer complaints or confusion about unclear documentation. We should also not assume users understand technical jargon. So jargon is a certain language that is only available to a certain company, brand, or a certain degree. A jargon by definition, is the language used in a certain profession. For example, in teachers, we have um, we have class attendance, we have um, grade sheet, attendance sheet, the grading system, the um, the HOTS or the TOS, the table of specifications. So these are important, and also lesson plan. So these are language that is only applicable in the teaching profession, and it's a different story when we are talking about law school or in the profession of lawyers, simply because they use the legal jargon of, um, for example, rule of law, um, a a decision or ruling from the court, and for example, this is a contempt of the court. That language, meaning that a certain person um is really um not following the orders provided by the court, and minamaliit niya ang kakayahan o ang impluwensya ng Korte Suprema, something like that, and don't refuse to update outdated or incorrect information. So, as like in a software, for example, in our cell phones or in our mobile phones, we always update our softwares so that it can work smoothly, and it is updated so that it can function to the latest version available. So in this presentation, ultimately we can deduce that technical writing isn't just about writing, it's about having clear responsibility. By following ethical guidelines, writers ensure their documentation is trustworthy, transparent, and user friendly. And now we go on to the key differences. So, legal issues are about following the law, while ethical issues are about doing what is right from wrong. So, this is understandable, right? So, by following the rule of conduct, just obligatory promulgated by legitimate authority for common benefit and observance, or the law, we can abide to this. We can we can abide we should abide to this so that we cannot be criminally liable and civilly liable and administratively liable as provided in the revised penal code or our penal laws here in the Philippines. And on the other hand, something can be legal but unethical. For example, it's like exaggerating a product performance in a manual without outright lying. So, for example, um, this phone, this is a phone that can transport you um, into becoming more guided about the new updates that it has. For example, a 1080p camera HD, and it really shows a video with blur um, blur features. With, so this goes to show that it is not outright lying. And something can be ethical but not legally required. For example, simplifying language to help users with low literacy, even if not mandated by law. So this goes to show that it's a means of helping those who are um, has men- mental or cognitive disabilities. For example, those on the autism spectrum, disordered students. So I also have a thesis regarding this about its autism spectrum disordered students and a psycholinguistic analysis. So yeah, low literacy persons should um, be given a simplified language user manual in order for them to really attain or really know the certain um, manuals or instructions provided in the um, guide or manual. So, with that, everyone, thank you for listening. I hope you have learned a thing or two about the laws that we have here in the Philippines. And again, nolum crimen, nolia pena sine regi. There is no crime and there is no law punishing the act. And dura lex sed lex, meaning it's a Latin phrase in criminal laws we have here in the Philippines that the law is harsh, but it is the law. So if you're criminally liable for the offense um that you um did or you acted in bad faith, so you can be criminally liable, civilly liable, and administratively liable. So I hope I have made explicit about these laws, and I hope you can um, apply it to the context of technical communication and in technical writing, and also apply it to in life and also your journey as an English language student or a BSed English student, and also in the near future when you become professionals. So that would be all. Muchas gracias a todos. Goodbye.